Hi, this is Kevin Quinley. I am an insurance claim expert and serve as an expert witness on litigated insurance matters around the country involving claims handling or alleged claims mishandling. The genesis of this brief conversation is the communication styles needed by experts in deposition setting versus the communication style needed in a trial setting. Realizing that most cases don't go to trial, but if they get to the trial, it's usually very high stakes. And what prompted my thinking on this was an article recently in the Washington Post talking about legal commentators, typically on the big news networks like CNN, Fox, etc., law professors and attorneys who are providing commentary on some of the political developments regarding our former president, and regardless of whether you're pro, con, or neutral on this. And it was talking about it interviewed various law professors and the challenges of communicating on these news programs and the different context. What jumped out into me, what jumped out to me, was that one law professor was saying that on TV you cannot get into the weeds, you have to speak in sound bites. And another law professor said that don't assume that viewers understand the legal system or details or are willing to sit down with elaborate explanations. You are not speaking to an appellate panel. I think there's a lesson there for expert witnesses and those who would become expert witnesses in terms of communication context during depositions and communication context during trial. In depositions, I think that you can let it fly in terms of using sort of technical insurance terms, abbreviations, things like that, because generally it's a more knowledgeable audience. If the case goes to trial, though, your audience is the jury. And there, I think it's very important that an expert witness, whether you're retained by a plaintiff suing an insurance company, for example, or retained by an insurance company defending against a bad faith or breach of contract claim, that you try to express insurance concepts and terms in very basic terms. I think during the movie Philadelphia, starring Tom Hanks and Denzel Washington, Denzel Washington plays the role of an attorney who takes, I think, an employment discrimination case for Tom Hanks, who's been booted, maybe booted from his law firm because I think he has AIDS. And at different times in that movie, Denzel would turn to a person and say, pretend I'm an 8-year-old. I'm paraphrasing here. I pretend that I'm an 8-year-old and explain it to me in those terms. And that's without patronizing a jury or talking down to them. I think you need to turn to the jury when you're in the witness box in the courtroom, try to make eye contact with each one of them, slow down, and try to make things as simple and concrete as possible. This also came up on a recent news item, and when CNN was covering the tragedy of this submersible that was lost at sea. And they had an engineering professor from Duke University who was talking about the susceptibility to failure of carbon fiber. Now, the shell of this submersible was made not of titanium or other conventional materials that submersibles were made of, but it was made of carbon fiber, which the inventor viewed as very innovative. But this engineering professor, she was saying that, carbon fiber is not the best material. It's neither carbon nor fiber. She used the example of a croissant. It's made of butter and it's made of dough, but it's putting those two together, you get a croissant. It was a blend of those two. She was kind of comparing a carbon fiber, which sounds very impregnable, to a croissant. I thought that was a clever way to, and especially carbon fiber that is repeatedly exposed to salt water and how that might affect its properties of strength at a deep depth of the ocean where the per square inch pressure is exquisite. So the takeaway is, just like um, legal commentators on TV, an effective expert needs to tailor their communication style and understand the difference between what you can say in deposition and what you can say, or what you should say, and how you should say it in front of a jury. That said, because so few cases actually go to jury, sometimes the deposition is the trial. So I'm not saying let loose in deposition with a lot of technical jargon, but your communication is often constrained because you're simply responding to questions posed by the opposing side. And sometimes that's it. Whereas at a trial, you have an opportunity through direct examination to, quote, tell your story. So break it down, simplify it for the jury. Don't be patronizing. Don't talk down to them, but beware of abbreviations and acronyms and insurance terms that may be second nature to us, but not to a jury, and break it down as if you're talking to an 8-year-old or a seventh grader. That's today's tip.